Good afternoon and good evening, everyone. My name is Evan Rutter. I'm the Assistant Vice President for Alumni and Parent Engagement here at CMC Class of 2006, and it is a thrill to have you back for our CMC Connect series. We typically go dark for the summer. We celebrate and honor our 25 new student parties, welcoming the incoming class of 2026. We wrap up alumni weekends and celebration weekends and all of our commencements, and we prepare for a very strong fall semester. But of course, something big happened over the summer. A lot of the Supreme Court decisions came down not too long ago, and the team said, we have to do something. Who can we get? And of course, we turned to George Thomas, who is one of our constitutional scholars here at Claremont McKenna College. And we're very excited to do this program before we kick off our fall series. A few things about Zoom before we get started. At the bottom, you'll see a bunch of buttons. First of all, there's a chat button. If you click that, open it up to the right, you can put your name, your class year, city, state. It's always fun to see where everyone's chiming in from. That's also how we're going to do the Q&A. There's a lot of us on the call. I'll pull the questions from the chat in about 20-25 minutes when Professor Thomas finishes his remarks. You'll also see a participant button where you can click on that and you can control your name. You can change things up a little bit if you want to change your name or change your phone number, whatever that may be. And top right is a view button. You can toggle between speaker or gallery view, however you want to view the program. Feel free to do so at your leisure. In that chat feature, by the way, you can talk with anybody who's here online. So maybe you see a classmate, a roommate, someone you haven't seen in a while. Feel free to send them a quick chat and say hello as well through the chat feature. So today we are discussing recent Supreme Court decisions, their impact, present, and future. We are here with George Thomas, who puts the second P in PPE. It's our philosophy, politics, and economics program at the college. Also was my major and a few other majors here at CMC. He's also director of the Salvatori Center, which he's been leading since 2018, which is our original research institute on campus here at the college. He's, of course, an expert in constitutionalism, American political thought, con law, and the Supreme Court. And with that, George, I'll turn it over to you.
Great. Well, thanks, Evan, and thanks, everybody, for coming. I know it's been a momentous Supreme Court term. I hope I can bring a little bit of insight to it. I want to try to keep brief while giving a big overview, because I know mostly you're here to discuss the issues and have a lot of questions that hopefully we can spend most of our time engaging in. But I thought I would just return to a little bit of history and thinking first. The big question with the court, of course, when Justice Amy Coney Barrett was confirmed at the very end of 2020, days before the presidential election, there was this great question with now sort of 5 committed conservative originalists, and I'm hesitant to use conservative and liberal, I'll say at the outset, for describing Supreme Court justices, because I don't think it actually maps completely onto conservative and liberal politics generally, but I'll go with those terms for now, and that's one of the things we can talk about. But there was this big question with the appointment of Justice Barrett. You had clearly 5 justices who more or less shared certain understandings. And you also had Chief Justice John Roberts, who shared some of those, but there had been some tension between justices like Alito and Gorsuch and Thomas and Chief Justice Roberts on just how sweeping they wanted to be when it came to implementing or going with their understanding of the law, which I'll spend a lot of time getting into as we go. So there's this great question, is a court going to go quickly on this, or are they going to go more slowly and cautiously? It seemed that Barrett and Justice Kavanaugh were sort of the unknowns. And I think our answer, which we got by way of a court leak, the first in its history of the Dobbs opinion, was the court's going to go pretty quickly. And that Chief Justice Roberts is going to be the odd conservative justice out on this. And when we think of the wave of constitutional cases handed down in mid to late June, it's really stunning. I mean, so stunning that I tend to forget that there was actually the appointment of a new justice, the first Black female justice, Justice Ketanji Brown Jackson. And it's hard to remember that there was this leak And it was the Dobbs opinion, which of course overturned Roe v. Wade. And that draft opinion turned out to be more or less the same opinion that the court would hand down toward the end of June. So what I want to do is I want to situate the court politically a little bit. And I want to get into the politics of it. What are the consequences politically of the decision? How might it play out in terms of elections and the like? But before that, I wanted to situate the court a little bit more historically. And I thought the place to begin was really to think about Roe v. Wade in the first place. Of course, the Dobbs case overturned Roe v. Wade, and it also overturned Planned Parenthood v. Casey. And a way to think about it is to start really with the Roe opinion, handed down in 1973. The Roe opinion recognized very clearly and for the first time a woman's right to terminate her pregnancy. To be clear about Roe, it said that there are really sort of two interests at stake. There's the woman's interest in liberty and personal autonomy, and that interest is sort of paramount in the first term of the pregnancy, well into sort of the second term, dividing it into trimester frameworks. But Roe also said, well, the state also has this interest in protecting prenatal life. And that interest is something the state's ability to regulate increases over time. So in the third trimester, the state has much more of an interest in regulating prenatal life than it does, say, in the first trimester. Now, what's interesting about Roe, if you think about it historically, is it's a significant case. It's the first time that a woman's right to choose to terminate a pregnancy is recognized as a constitutional right. But in terms of sort of explosive politics we associate with Roe, it actually wasn't that explosive at the time. It was a 7-2 opinion. And we should remember that two prominent conservatives appointed by Richard Nixon joined the opinion. One of them wrote the opinion. Justice Blackmun was a recent appointment of Richard Nixon's, and he was the author of the Roe opinion. But by the late 70s, there are a lot of critics of Roe. Some of the critics from the beginning, I should say, are actually liberals and progressives who think that it's not a particularly well-reasoned or powerful opinion, but it becomes much more of a flag point for conservative politics, not just for Catholics, but for evangelicals. And we should also think about at the time, there were a lot of what would become through the 80s, a lot of pro-choice Republicans, and there were a lot of pro-life Democrats. That has sort of sorted itself out so that these days you see very little overlap in that regard. But just to think about Roe, you get with Roe, especially in the 1980s, a conservative legal movement that thinks Roe is just profoundly wrong and wrongly decided. And they start to articulate a constitutional vision, one that they will attach to what's called original meaning, and I'll situate that a little bit more in just a moment. But so the argument for, at least the modern argument for original meaning and a deep critique of Roe really catches up in the 80s. And what you're seeing now, sort of the culmination of that, right? And the other piece of the puzzle to add to that story is that in 1992, after you'd had Republican presidents in President Reagan and President Bush appoint a number of Supreme Court justices, and they were confirmed to the court, most notably Justice Clarence Thomas, Justice Anthony Kennedy, Justice Antonin Scalia, and then Justice David Souter. Now, the catch is that in 1992, you got a case that was, for many conservatives, the case that should have then overturned Roe v. Wade. And it didn't, right? In a famous plurality opinion written by 3 conservative justices, or that becomes the subject of debate, 3 justices appointed by Republican presidents, Justice Anthony Kennedy, Justice David Souter, and Justice Sandra Day O'Connor, they uphold Roe v. Wade. And they say in that opinion that they're not necessarily sure it was rightly decided in 1973, but given circumstances, given precedents, given the fact that women had come to rely on the opinion over nearly 20 years, that they thought it ought to be upheld. This becomes a really galvanizing point for conservative legal thinkers and conservative politicians and the Republican sort of establishment generally. And the idea was that Casey is really profoundly misguided and that it was deeply political. So, I mean, that's all in a run-up to say that, at least from the perspective of Republican politicians, from the Republican legal establishment, from conservative legal thinkers of many sorts, not just the Federalist Society, and from originalist scholars, while we're seeing sort of sweeping change at this particular moment, they view it as a constitutional restoration. They see Roe as profoundly misguided from the beginning, and several of these other cases that we'll touch on in a moment. And so their understanding is that Dobbs is a kind of constitutional restoration that's now returning the issue where it properly belongs, and that's to the states, where the states can now sort things out and decide. Now, whether it's that simple is something I really want to spend some time talking about. I'm sure there are questions about, but I just want to put that out up front, because for these justices, for certainly, I think 5 of the justices on the court, the Republican senators who approved of them, the Republican presidents who appointed them, they understand this is restoring the court to its proper constitutional role within the separation of powers. Right now, I want to give the critics their due as well. Critics say that if you go back to Casey, and Casey had 20 years reliance on Roe v. Wade, then what's particularly interesting about Dobbs is you've now had 50 years of precedent here of women relying on this decision. And they want to argue that the court has sort of very quickly and very swiftly overturned a precedent that stood for half a century without giving much consideration to the rights at issue and how that would affect the rights of women. And critics also want to point out, right, that we can't move away from the politics of this, that really the current court has to be understood in terms of first thinking that Justice Antonin Scalia passes away in early 2016, about 10 months before the presidential election. For the first time since 1840, the Senate simply says, we're not going to hold a hearing on the president's nominee to the Supreme Court, Merrick Garland, who's currently Attorney General. Not coincidentally, I should say. So critics then say, all right, there's another piece of the puzzle we have to think about, and that's that when you jump to Amy Coney Barrett, right, she's appointed by a Republican Senate weeks before a presidential election. So they are saying, like, logically, you could pick Gorsuch or you could pick Barrett, but you can't have both and be logically consistent. So they want to say this is deeply political all the way down. And it's the Senate and the Republicans politicizing the court, and a court that seems ready and able now to institute sweeping constitutional change and implement a conservative vision. I actually think those are sort of like the two polar opposites of the story of the current court. I think there's a lot of people in the middle of that, and we can talk a lot about the middle, but I wanted to give sort of due weight to both sides because I think it's important to understand how each side really sees the current court. Having said that, I want to turn to the Dobbs opinion and spend a little time on it, and then just kind of quickly say why I think Dobbs is so important for the Second Amendment gun rights case, as well as the 2 religion cases that deal with both Establishment Clause and free exercise. And then I want to say just a word about the EPA case, because I think when we kind of take these as a whole, whether you think it's a really healthy and good development or you are deeply skeptical of it, it does represent a profound shift, or potentially profound shift. It will sort of depend what unfolds over the next year or so, profound shift in how the court approaches constitutional interpretation and how it understands itself within the separation of powers in the constitutional order. So the first thing to think about in Dobbs is it obviously overturns Roe and Casey, right? And the logic of Dobbs is important because it's going to have serious implications, as I'm sure you've read, for a number of other cases. And so in the Dobbs opinion, Justice Alito finds that a woman's right to terminate her pregnancy is simply not part of the liberty protected by the 14th Amendment. Now, just to back up and be clear about this, right? The 14th Amendment, first of all, in its due process clause, says that no state shall deprive any person of life, liberty, or property without due process of law. So the question is, what's the liberty you can't be deprived of without due process of law? Now, in Roe, the court had said, again for the first time, that that liberty includes a woman's right to choose to terminate her pregnancy, although it can then be weighed against other interests of the state, protecting prenatal life, for instance. Now, Alito's analysis says, all right, so is this a liberty protected by the 14th Amendment? And his method, and I think this is what's not just significant about Dobbs, but you're going to see spill over into a number of other cases, is based on history and tradition. Now, as you probably know and have heard, the court is right now, is currently constituted, deeply influenced by the idea that the Constitution or constitutional text ought to be understood as it was originally understood at the time of its ratification. I want to say just a quick word about this. And it's interesting because Alito himself is not always a very clear originalist in these terms. And a lot of originalist scholars think that Alito's opinions aren't originalist at all, and they don't even think that Dobbs is a very good originalist opinion. But just to situate original meaning in this context, and then you can see how Dobbs relates back to Roe, the idea with original meaning is that the Constitution's text ought to be understood and interpreted as it was understood by those who framed and ratified the Constitution. And original meaning is actually places the importance on those who ratified the Constitution. So even though you hear, especially Republican politicians, talk a lot about framers and framers' intent, originalist scholars and originalist justices, especially like Justice Gorsuch, think that the framers, James Madison, or an Alexander Hamilton, are very important, but they're really only important insofar as they give us insight into how the public understood the text at the time it was enacted. And the argument for originalism is really sort of twofold, and there's been some tension over the years, and that's one of the things I want to talk a little bit about. And it's twofold in that originalists mostly argue these days that we are obligated to follow the original understanding of the text because that's what makes it law. So it's when the public enacts that text, that's when that becomes law and binding on us. Now, the second part of it, and this becomes very important to Alito's opinion and Dobbs, is they argue that if we turn to history and we look for rights in history and tradition, that limits judicial discretion. So it can discernibly cabin how the justices think about something like liberty. Liberty is a pretty open-ended phrase. So how do you keep justices from saying, well, whatever rights they happen to think are important are, of course, part of liberty, and those they don't think are important aren't? Originalists argue you turn to history and tradition. And so if a right is clearly recognized in historical terms, if it's been traditionally protected, then that right can be understood as part of the liberty protected by the 14th Amendment. And the idea is you do this sort of with any clause of the Constitution. So 1868 is the important year for the 14th Amendment, 1870 for the 15th Amendment, 1791 is the important year for the First Amendment, right? Or when you're talking about executive power, right? Or congressional power, 1791 becomes, 1787, 1788 becomes the important year. Now, I want to sort of just quickly go through Alito here, because Alito then asked the question, okay, so when we turn back historically, has a woman's right to terminate her pregnancy been a historically protected right? And some of you have probably read, right? He goes back into the common law, and he goes back as far as the 13th century, which is, for some originalists, they were like, yeah, he's reaching a little far there. He doesn't need to really go that far back, and that might not even be that illuminating, but he wants to trace the right potential right of abortion in the common law. He says it's not there at all. But then he really turns to, so was this right protected about the time that the 14th Amendment was ratified? And Alito's answer is a sort of obvious and resounding no. And because it's a no, he says this right is simply not protected as part of the 14th Amendment liberty, right? And because it's not protected, Roe and Casey were profoundly wrong the day they were decided, and they ought now to be overturned. We can talk about why precedent should matter or not matter in the Q&A. I just don't want to spend a lot of time there. But critics certainly are like, look, but it really matters that this was a constitutional right for 50 plus years, and you ought to give that some thought there. What I want to highlight, I think this is what's going to become the important debate going forward, is that Alito has an interesting qualification in Dobbs, as you've also probably read. He says, okay, so this right is not constitutionally protected because it's not grounded in history and tradition. It wasn't part of any understanding of those who passed the 14th Amendment. But then he adds, okay, but this is only about abortion rights. We're only reasoning when it comes to Roe v. Wade. And that's because at issue in Roe is this state interest in potential life. And because the state has an interest there, its reasons for regulating women are more compelling than they might otherwise be. But what he wants to do then is say that when it comes to contraception, which is also not mentioned in the Constitution, sexual intimacy, which is also not mentioned in the Constitution, or same-sex marriage, which is also not mentioned in the Constitution, this case doesn't have anything to say about those, right? Now, I want to jump to Thomas. Justice Thomas, in his concurring opinion, he very much agrees with Alito's analysis of Roe v. Wade, but he says, nonsense. It applies to all of those issues and cases as well. So Justice Thomas wants to say the court has taken a profoundly wrong turn when it comes to protecting any so-called unenumerated rights under 14th Amendment due process. So when it comes to contraception, sexual intimacy, same-sex marriage, Justice Thomas would say we should jettison all of those cases as well. Those cases should be overturned to restore us to a proper understanding of the Constitution. Now, interestingly here, the dissent, and there's if you haven't caught it, there's something novel about the dissenting opinion here. The dissenting opinion is not single authored. All three, and this is unusual, all three justices, Breyer, Sotomayor, and Kagan, you can kind of tell which justice wrote which piece probably, but they all jointly sign it. And the idea is that they want to stand together on this, and they agree with Justice Thomas. They say, look, the court is wrong. If we accept the court's logic, and we accept the court's opinion in Dobbs, very clearly, contraception as a right, sexual intimacy as a liberty right, same-sex marriage is a liberty right, and even interracial marriage is a liberty right. They are all at stake. In fact, the dissent goes further and says even things like the idea that the state could actually sterilize you if it found you to, say, be mentally incompetent, something that they did in the 19th and early 20th century. The dissent goes, that's up for grabs if we take the court seriously in Dobbs. So, I mean, I know that's going to be where a lot of the discussion is, and I want to put that out there now just in terms of thinking about their opinions. Let me just highlight sort of two things in wrapping up, and again, so I can really open it up to questions. I think what's potentially most interesting here is that the history and tradition analysis, it's not totally novel. It's been around for a long time, and it's been in strands of constitutional thought. Going back not just decades, but really centuries in a way. And you definitely see articulations of it by New Deal justices like, say, Felix Frankfurter, thought that really how we understand due process is something that really should be historically informed. And we turn to the history, and that history tells us how we ought to understand, how due processes worked in what he calls the Anglo-American legal tradition. What's different here is that the court is really saying that history and tradition are what are going to determine not just how we understand rights, like the Second Amendment right to bear arms, but it's also how we're going to understand things like the Establishment Clause. When can states support religion? When can they not support religion? And the Free Exercise Clause. So in the Second Amendment case, and Braun, the case from New York, where what was at issue was the state of New York, like the state of California, said that if you wanted to have a concealed weapon, or concealed carry, as it's called, you had to go to the state and demonstrate a cause. So why do you need concealed carry? And those laws were called, the state may issue that to you, but you had to, but the burden was on the individual to prove that they needed it. And the court said that burden's unacceptable because those laws have not been a way that we've historically regulated a Second Amendment right to bear arms. And so in Justice Thomas's opinion, it says what should determine how we think of the state regulating a right will be determined by history and tradition. And that, built on earlier Second Amendment cases, which themselves are pretty new. The Heller decision, which really recognized a individual right to bear arms, is only from 2008. And the opinion that quickly followed, McDonald v. Chicago, was shortly after that dealt with the individual right to bear arms against state law. So the other two areas where you really see this as well is in the religion cases. And the first of those, and I'll be really brief on these, you've probably read about them. The first was simply that Maine had said that because it has public schools, but then there are a bunch of rural areas where there's no nearby school, Maine had said, okay, we are going to provide tuition to those to individuals who are going to go to private schools, but they cannot use it at a sectarian or religious institution. And some of those laws date way back into the middle years of the 19th century, where states said, hey, we don't want to fund religious activity. Now, what's, I think, important about this case is the court had said in the past that a state may choose to allow individuals to, say, use vouchers or scholarships or the like at a religious institution. What was important was that it was an individual choice, right? But in Chief Justice Roberts' opinion, in the Carson case, which is the main case, the court said when the state undertakes to provide, say, scholarships or funding for secular institutions or individuals who can choose secular institutions, it also must offer those to sectarian or religious institutions. So it went from a may do this if the state chooses to the state must do this. And Roberts's argument also drew deeply on history and tradition, saying that the historical understanding was how we really ought to understand free exercise, and that it was discriminatory for a state to pick and choose and say, we're only going to fund, say, private non-sectarian education, rather than allowing individuals to make that choice. The second religion case was the praying coach, as it was called. And we can get into this one if you want, but this is one of those weird cases where there's a huge dispute about the facts. And it's the first time ever I can recall in a Supreme Court opinion, a photograph, because Justice Gorsuch, in his opinion, said that the coach was engaged in private prayer and personal prayer and had simply invited others to join him. And so he had to be allowed to engage in that prayer, and that to prohibit him from that was to discriminate against his religious free exercise or free speech. And what's unique about Gorsuch's opinion here too, is it also clearly turns to history and tradition to inform our understanding of free exercise and the Establishment Clause. And both opinions want to argue that the Establishment Clause should really be understood in historical terms as only prohibiting coercion from the state. Otherwise, you get wide berth in terms of free exercise. But when Gorsuch described this as a private prayer in personal time. Justice Sotomayor put a picture of the coach praying at the 50-yard line, surrounded by people, and was just like, this is not private prayer. So, I mean, there's a big factual dispute about that case. But again, what's important, I think, in terms of constitutional development here, is that you're really seeing a court determined to read the text of the Constitution, particularly when it's disputed or unclear, based upon historical understandings. Now, the catch is, in the dissenting opinions, especially by Breyer and Kagan, they accuse, and again, we can open this up to questions, they accuse the justices in the majority opinions of picking and choosing history. They're like, look, history is deeply contested itself. History doesn't simply answer these questions. So turning to history is a way to simply say, okay, we're going to limit and cabin how courts and judges understand constitutional texts can be limited by history. They say that's simply not the case. And the court itself, they insist, is picking and choosing the history that suits it. So for instance, dissenting, it's its last great dissent, I suppose, by Justice Breyer, who's no longer on the court. He insisted that Justice Thomas in the Second Amendment case was simply lining up those historical pieces of evidence that fit his case, and then ignoring and discarding the other ones that may well support sort of robust regulation of guns. And so I think that's going to be really the big issue. Let me just be really, really quick on the EPA case. It gets into the weeds in a way, and I would like to avoid that. But what's important about the EPA case is the court there said, and it's also kind of stands apart because while it's written by the Chief Justice, and there's an important concurring opinion by Justice Gorsuch joined by Justice Alito, what's interesting about it as a case is, unlike the other four cases I just mentioned, it doesn't actually talk a lot about history or tradition to understand the text. So that's just something to think about. Why is that case so different there? But in the EPA case, the Chief Justice argued that an Obama era regulation from the Environmental Protection Agency that sought to shift the regulation of coal and move it to more clean production like wind for electric production, that shift from an administrative agency needed to come directly from Congress. So, and this is where it gets a little bit complex, but I think it's got an important punchline, and that's that the Chief Justice argued that when Congress delegates its power to an agency, so not just the EPA, but other agencies going forward, and that agency is regulating what the court calls a major question, then it has to be absolutely clear that Congress delegated that particular power to the agency so it could engage in the regulation. So when it comes to, and then there's going to be a lot of argument, how do you define major, how do you define minor? But when it comes to major questions, Congress has to clearly say, here is the power to regulate. And so in Robert's opinion, he would kick it back and Congress could come back and say, okay, we're going to give the EPA this power. Now, Gorsuch's concurring opinion, joined by Alito, is more interesting in this way. It raises questions of what's called the non-delegation doctrine. And it says that the idea that Congress can delegate its power to an administrative agency in the first place is constitutionally suspect. Now, it's not clear how far they'll push that, but certainly Justices Gorsuch, Alito, and Thomas have been thinking along these lines for a while. And the idea there would be that a lot of the executive agencies we take for granted, where a lot of regulation comes from, it's not just, as the Chief Justice says, that Congress has to be really clear when it's delegating its power to them about what they can do in terms of regulation. It's that the delegation itself might be constitutionally problematic. So if that's true and that line gets picked up on, then a lot of the administrative agencies that we've lived with from the New Deal on are going to become constitutionally suspect. And there are those originalists who say, yes, the New Deal took a deeply wrong turn and it created an administrative state that is constitutionally suspect. And you certainly see some of the justices embracing that kind of thought. So it might be, even though it's not, I guess, as sexy an issue in terms of being discussed in the press, it may be it will almost certainly be a deeply important case for how we think about the separation of powers and regulation and administration going forward. And I will end on that note and entertain questions, thoughts. Please, I'd like to hear all of it.
All right, thank you, George. We do have some questions in the chat already. If you have anything you'd like to ask Professor Thomas, please put it in the chat. First question, George, whatever happened to the talk of packing the court that was discussed in the early days of the Biden administration?
Yeah, I mean,
now possible.
Packing the court, right? That's it's still people still talk about it, and it's something to think about insofar as just to situate the court. There's no magic number. 9 is not a magic number. It's not a constitutional number. The court has had as few as 5 or 6 justices, as many as 10 justices. They've been added and subtracted for political reasons in the past, but essentially it's been stable since right after the Civil War at 9, and that now just seems to be where we are. But you're right, Congress can absolutely do that. Congress could also, make alterations potentially. Probably needs constitutional amendment, in my opinion, but in terms of actually term limits for justices. But there are some complex arrangements. So all those things can be entertained. I guess my one thought is I know lots of people who insist on packing the court, and I get part of it. I mean, it's hard to say that when you think of the logic that Mitch McConnell and Republicans in the Senate put forward with regard to why Gorsuch could be confirmed after an election, and we couldn't consider Merrick Garland, but then you turn to Barrett, it's pretty hard to square that circle. So I get the frustration. I guess I would say why court packing is maybe a non-issue right now is you've got a 50-50 Senate. Court packing is going to take a lot more than that. So those who want to pack the court have to win a lot more elections. And I would say just as a thought here, I think what's maybe most important about people who disagree with these decisions and are kind of settling into how they think about them is if you look over the sweep of American constitutional history, American constitutionalism is much, much wider than the courts. And those who, shape constitutional meaning, think about it, and we come to realize certain understandings. It involves not just social movements, but presidents, members of Congress. And so hopefully that would be one of the healthy developments, I think, in reaction against a court if you disagree with the opinions.
Thank you, George. Next question. Do you have any insight into what's driving the conservative justices? Do they truly want the conservative legal result without care for the policy impact? Or do they want the conservative policy and they're making up law to get that result?
I mean, that's a it's a fraught question, and insofar as it's hard to get in their heads. Anyway, I'll give you a quick take on it. I certainly think that all of the justices take their constitutional reasoning seriously, and they're persuaded by it. I don't have any doubt that the 6 justices, the 5 who really went in Dobbs, think that Roe is just profoundly wrong as a constitutional decision, and that they don't think it's justified in terms of their constitutional logic. And so I think that they're sincere there. I guess the real question comes when you're thinking of other cases where they should maybe also be thinking about history. So for instance, the EPA case, I said it's notable that it doesn't have a lot of historical analysis, and it's not clear that the non-delegation doctrine or the major questions doctrine is supported when you turn to, say, the late 1790s to think about Congress and the executive branch there. So that does suggest, look, there's some politics potentially going on here. And my, where I think that you really see this is it was sort of shocking to see a couple of justices insist that the court wasn't political at all in what looked like pretty political venues. Justice Alito speaking at Notre Dame to a bunch of conservatives and saying, it's awful that he's being criticized. It's like a justice should just, if they really want to say that, look, we're not political, we're not involved, I think they should do events and the like. but that seemed like a pretty political place to do it. And then Justice Barrett, standing next to Mitch McConnell at the McConnell Center, was saying, "Oh, we're not political at all, and we shouldn't be treated like political hacks." It's like, well, your case might be better if you're not standing next to Mitch McConnell saying this, right, at what looks like a political event. So, I mean, I think it's a mix of both.
Does Dobbs put at risk the application of the Bill of Rights against the states because of its substantive due process holding?
Yeah, that's a really excellent question, and I'll try to be really quick so we can keep taking questions. But I mean, I don't think it puts at issue the Bill of Rights itself. I mean, and why I think that's an intellectually interesting question is because, for instance, there are lots of critics of so-called substantive due process. That is, right, the idea that the Liberty Clause of the 14th Amendment, which you were talking about, protects so-called unenumerated rights. What's odd is that in the middle years of the 20th century, the court said, "Oh, but the Bill of Rights applies to the states by way of the 14th Amendment," and they kind of did it on a case-by-case basis over time. But it's now become kind of conventionally accepted. But that itself is a sort of substantive due process insofar as it's not like the 14th Amendment says, "Oh, the liberty we mean to protect are those rights named in the Bill of Rights." That would have been easy enough to say. Now, maybe that's actually what they mean, but the idea is that to say like, "Oh, well, 14th Amendment due process protects those rights named in the first 8 amendments to the Constitution." I mean, that's like really based on the same kind of unwritten understandings that Alito says would lead us to reject, say, the right to same-sex marriage or a woman's right to abortion. I mean, that might be a little abstract as a constitutional point, but I think it's actually an important one. But I actually think in so far as not just the Bill of Rights, much more importantly, when it comes to sexual intimacy, contraception, same-sex marriage, I don't think the court can simply say, "Well, we're not interested in those cases," because it doesn't depend on the court. It's going to depend upon what states do. And already you're seeing states, I mean, I want to say Georgia has what looks like a heartbeat law that's now like, look, once there's a heartbeat, that's a life, and they're going to push that. You have others, Ted Cruz was just on a show saying that the same-sex marriage case was profoundly wrong. And you have states who are pushing to revisit those issues. So I think that will really depend upon the states there and what political actors do. And I don't think the court's going to be able to hold those cases at bay. I mean, from the looks of things, they're coming its way. Now, maybe it can decline to hear them and just decide it's going to duck the issue, but I don't know that it will really be able to.
Was the Lemon test actually overturned in the Kennedy case? The dissent says it is, but the majority doesn't use those exact words. Gorsuch basically just says Lemon has been a dog's breakfast for a while now. Will the lower courts take this as guidance not to use Lemon anymore?
Yeah, that's a great question. I would say it's effectively overturned. Just for those of you who don't know who the Lemon test is from a 1971 case. And it was kind of a complex understanding of the Establishment Clause, but the gist of it was that you couldn't have excessive entanglement between the state and religion. And so any kind of law, like potentially the state funding sectarian institutions, then those would probably fail Lemon. The interesting thing about Lemon, like a lot of Establishment Clause and Free Exercise Clause jurisprudence, it's sort of a mess in the first place. And so, I think Gorsuch is not altogether wrong that the Lemon test has sort of come and gone. But then critics, the dissenters, for instance, were like, okay, but if you are going to formally overturn this precedent, you need to then engage in an analysis that explains why you're overturning it and be very clear about that, not just say that, well, it's sort of been neglected, so we're like no longer following it. And so I think that's a fair criticism from the dissent. That is it overturned or not? Be really clear about why you're overturning it, and if you think the court has really already overturned it in past cases, be clear that they were right. and that you're now really going with that, and this is why you're clearly overturning it now, because it was because again, critics would say Lemon was misguided from the beginning. It's not supported by history or tradition, and so if you're following that, you should be saying Lemon was just wrongly decided.
At oral argument, Kavanaugh pointed out 60 years of separate but equal precedent under Plessy, building reliance, interest, and segregation. Brown overturned Plessy, and it was universally seen as the right thing to do to an egregiously wrong judgment. Alito repeated that in his Dobbs ruling. Roberts seems to believe in a far stronger theory of stare decisis. Has the idea of an unoverturnable precedent for the court been shown to be a myth? Whatever happens in the future on this issue, Roe has been overturned at least once, despite Casey saying it couldn't happen.
Yeah, I mean, I guess I agree. Just a quick word. I mean, precedents are one of those sort of notoriously vexed issues. I do think Chief Justice Roberts wants to be clear when precedents are being overturned and why, and would go more cautiously. Those are his judicial instincts. Justice Thomas at the other end of the perspective thinks that precedent shouldn't matter. If precedent got the Constitution wrong, it got the Constitution wrong, and the court's now obligated to follow the Constitution, not precedent. I think most other justices really kind of have a mix, and there's a huge argument about when it should be followed and when it shouldn't, not just in Dobbs, but obviously, for instance, the Lemon case, and certainly, yes, Roe's been overturned. Now, are there precedents that I don't think that people will touch? I think Brown v. the Board of Education is probably one, but I've been surprised by a lot of things in the last 7 years, so I could be wrong there.
Is the doctrine of substantive due process going to be weakened by the Roberts Court? How does this relate to the conflict between the 10th and the 14th Amendments?
What's the conflict between the 10th and the 14th Amendments? I have to know. I mean, so while whoever asked that question is coming up with maybe a thought there.
David.
I think substantive due process. Again, I know this is, look, it's a kind of a weenie academic point, but when you apply the Bill of Rights to the states, that's kind of substantive due process too. I mean, it's a complicated argument, but because it's not like the 14th Amendment doesn't say the first 8 amendments of the Constitution are what we mean by liberty, right? You have to engage in the history and the substance of that argument. But absolutely, the Roberts Court's going to limit substantive due process. It just did. Dobbs did it. Thomas is itching to go for same-sex marriage and contraception and same-sex, and not just same-sex intimacy, I want to be clear, sexual intimacy generally. Whether there are other justices who will line up to do that, that's, I think, really the open question. And there it might not, to go back to the question about, how much is this sort of law and constitutionalism, how much is it politics? It's some of both. I don't think it's just ordinary politics, but certainly, Kavanaugh might be like, I don't want to go down that road, and I'm not going to really think about whether it's intellectually consistent or not. I think he probably thinks it is, but I think the Roberts Court is clearly going to limit that.
David's with us to clarify his question. David.
Yeah, what I was getting at was that when the 10th Amendment was written at the founding in 1787, the thought was that the Bill of Rights was restraining the federal government.
Right. Okay.
So the powers that were not enumerated in Article 2, Section 8 of the Constitution were the powers were retained by the people and the states. So, but then when the Civil War happened, the Union was worried about the South regaining a power if it joined the Union, and they wanted to make sure the state governments couldn't oppress their citizens, especially the Black citizens. So the 14th Amendment was sort of a assertion of federal domination, that the federal government now had the power to protect rights. And I just see that that's sort of an imbalance that the court is grappling with all the time, is that in 1787, there was sort of a different theory about how things worked. And then the 14th Amendment sort of upended that. And that's where I think, all these decisions with overturning Roe and the lemon test being thrown out, all those I think go back to this root problem.
Yeah, I mean, that's a great question. I guess I would say, I think that's a right on the 10th Amendment, but the 14th Amendment then as an amendment does change that. And just for instance, right, there were those, James Madison, for instance, tried to get the states limited when it came to freedom of speech and religion early on. And that was an amendment he put forward, but it actually never made it out of the Congress, so it never even made it to the states. But the 14th Amendment then says, look, there have been a number of problems, and those problems revolve around states depriving not just Blacks, but others of their rights. And so we need to constitutionalize against the states the protection of individual rights. And I do think they mostly meant to do it originally by way of privileges or immunities of citizenship. And that's why citizenship was also so important. But it does raise questions of it's a great question to think about when you're thinking about sort of originalism in the court's approach, because there's always these arguments about, all right, so even if you're trying to understand things historically and the text as it was understood historically, as almost everybody does, and then the question is, should that be the definitive thing that guides us? And is it clear in the first place? And then there are also questions about how, abstract should we read things and how concretely should we read those understandings? Those are all questions I don't think you can really duck and avoid. I mean, those are just the kinds of questions that come with textual interpretation. But it's a great question when you're going back to the 10th, you have to sort of read it in light of subsequent amendments. Just so for interest, it's just interesting to think about, because some critics say of Justice Thomas's Second Amendment opinion, who are sympathetic to the decision, but they think his analysis really should have focused almost entirely on 1868, the 14th Amendment, rather than the 1790s, where he really focuses things. So again, I think that the 10th Amendment, 14th Amendment is a great question there.
Thank you. We're running short on time, so we're going to miss some of the questions. So I do apologize, but I know that Professor Thomas will return at some point. He's also very easily accessible. There was one question that came through that from Ada Hand that said, can Supreme Court justices be impeached? And I think, George, that probably, or maybe if you could also comment, when you comment on that, talk a little bit about the theory or the discussion out there about that some justices in confirmation hearings may have perjured themselves based on their response to Roe v. Wade.
Yes, justices can be impeached, and we've actually have impeached judges, and a justice came very close to being impeached. Was impeached, was not removed, and that's Samuel Chase, who was it was interesting. He started out sort of as a critic of the Constitution, became a serious Federalist, and he was a judge who did things that you wouldn't think were very judicial these days when it came to Sedition Act trials. I mean, so he was hectoring the defendants and acting in deeply political ways. And so when the Jeffersonians won power in the election of 1800 and Jefferson came in, one of their targets was to impeach Justice Chase. But like impeaching Andrew Johnson, it didn't turn out. I actually think the impeachment power should have been used more. I think actually, if you want to go with original understanding, I think the founders would be surprised to say, wait, you never removed a Supreme Court justice and you never removed a president? That seems a little odd. Maybe like a couple could have happened. But essentially, when that didn't occur, that I think it's unlikely, but they absolutely can be impeached. The idea that the justices perjured themselves, I mean, I don't know, color me skeptical there. I get it. But when I guess my view, and maybe this is too cynically political, when they said Roe is precedent, it's like, yeah, it is. It's a factual statement. I respect that precedent. I respect it in such as its precedent. And am I going to overturn it? I wasn't surprised when any of them did, I have to say. I know Sue Collins is. I'm surprised that she's surprised, I guess. I mean, there's a serious case of confirmation hearings. Are the justices really playing a game? And that's not okay. I don't think so. I agree with that part of the question, but I think that's on the Senate. I think Senate confirmation hearings also, if you want to think of it in an originalist perspective, just in terms of kind of like, how were we thinking about this should work? It's shocking that the Senate sort of plays this game where they allow would-be justices to say, I can't answer that question. I mean, they'll talk a little bit about their judicial philosophy, and they shouldn't say like, here's how I would decide this case. That would be inappropriate. But there are all kinds of questions that can sort of probe more than that. And if they refuse to answer them, then the senators could simply say, we're not going to confirm you. And that would be a healthy development, I think. So the Senate has the power to do that. I mean, it's because I do think confirmation hearings are sort of more politicized in that way. And that would be it would be nice to get away from that. But the Senate has far more constitutional power there than it really uses.
Thanks, George. Last question. The court's recent decisions tend to be out of step with the majority of public opinion, and they tend to be very political, as you've noted recently. What do you predict will happen to the court and the country as a result of this?
That's a really good question. And there's a sort of famous line that says, that in the end, there's a lag, but in the end, the Supreme Court follows the election returns. I don't think that's entirely true, but I mean, it certainly is an issue that when you look at some of the court's opinions, they are very out of line with public opinion. And so you would certainly think that if public opinion rallies in a way that the court, it's not clear that the court will take notice. It might. I mean, on one level, the court, I think, is right to say we shouldn't just be swayed by public opinion. I think that's probably right on lots of issues. When we think of why we want an independent judiciary, particularly when it comes to protecting individual rights, right? We don't want them to simply go with public opinion in that way. But how sustainable is it if they get so far out of step? I mean, the one thing that I think could happen is you could if these rights are really popular, and you persuade your fellow citizens of them, which shouldn't be that hard if they are, they can be protected by way of legislation. I mean, again, I want to just emphasize, as important as the court is, we tend to be preoccupied by the court on constitutional issues, when historically, in fact, the court is not always the most important player. I mean, so just to kind of highlight this, Brown v. the Board of Education was very important. I think the Civil Rights Act of 1964 and the Voting Rights Act of 1965 were much more important than Brown in the long run. And that's a real instance of securing rights by way of legislation. That was also true of the Reconstruction Congress, secured rights by way of legislation, by way of its great civil rights acts. So, I mean, I think if public opinion is really there, then you can channel that legislatively speaking, and you could secure rights that way. And the truth is, rights are probably more secure when secured legislatively and they have wide public support than just judicially.
Fantastic. George, thank you so much for your time. Thanks to everyone for their time today. We look forward to welcoming all of you back in the fall for future programming. We have an excellent setup of everything from intellectual opportunities and continued learning to wine tastings returning to our virtual programming. For those of you that want to seek out CMC merchandise, check out CMC Supply Shop. There is currently a sale on all 75th merchandise as we clear those items out and replace them with Rose Parade items moving forward. Have a wonderful evening, everyone. Thank you so much. Be safe, be healthy, and we'll see you soon. Feel free to unmute, say thank you, and we'll see you all soon.